Thank you, Jim. When I first joined the Brooklyn Law School faculty back in the 1980s, my office was across the hall from that of professor at the time, David Traeger. He had previously been U.S. attorney, and it was before he became dean. And one of the things that I quite vividly remember from that fall was a number of mornings I would walk into my office work, and David would say, "Hey, did you see that great case the Supreme Court decided yesterday?" And I would be thinking to myself, what is he talking about? The only Supreme Court decision I remember noticing was that perfectly awful case where the Supreme Court just limited a right that I thought was absolutely essential. And then as I was struggling to think what he would, I saw the gleam in his eye, and I realized, as David would say, the truth of the matter was that we were talking about the same case, and he was looking for a lively discussion. So yeah, I think what could be more fitting than the lively discussion that we expect to have today. I thought I would start by telling you that a few months ago I was down in Memphis, Tennessee, and went for the first time to the Civil Rights Museum, where among the very many fascinating exhibits that they have a telephone that you can pick up and listen to a tape of a conversation between President John Kennedy and Governor Ross Barnett. And the conversation took place just after James Meredith had arrived at Ole Miss, and I'm sure all of you recall, even those who were not alive at the time, that this was not a popular thing, and there was a whole lot of mob disturbance at Ole Miss. So President Kennedy had Governor Barnett on the phone as he was trying to talk about what he believed was their common goal of restoring law and order on the Ole Miss campus. And he was talking to Governor Barnett about whether he could bring in some local troops to quell the riots, at least maybe until the federal marshals could get there. And listening to this tape, I gradually realized, as President Kennedy did himself, that they did not have common goals. And finally, Governor Barnett said to the president flat out, he said, "Well, Mr. President, you have your law to enforce, and I have mine." It seems to me that, in large measure, the history of federalism is the history of our country. Justice Kennedy said a few years ago that the framers of the Constitution split the atom of power and developed these different levels of government. And there have been many different theories ever since as to why they did that and how those subatomic particles are supposed to be reacting against each other. Teaching constitutional law, I frequently teach the fundamental decisions of Justice John Marshall, where you get a glimpse of what it must have been like in those early days for the court to be reinforcing the power of this fragile newborn federal government against these mighty states, like the state of Virginia, the Commonwealth of Virginia, which thought that it should have the last word about what federal law was. Very important sense of states' rights. The whole idea of the conflict between national authority and local autonomy has played out during every critical era of our history. Paul Finkelman's going to talk about the slavery debates, which of course pitted national authority against local autonomy in many interesting ways. The Civil War itself, I recently had a cab driver in Richmond, Virginia, who told me that every student in Virginia in public school in 4th grade takes a course in Virginia state history, because after all, what could be more important? And what they're taught is that the Civil War, contrary to what Northerners believe, was not about slavery, it was about states' rights. That's what Virginia continues to believe. It's all about states' rights. The Reconstruction era, of course, was about a recalibration between national authority and local autonomy and what the federal government was going to do about those states' rights. The first half of the 20th century involved the growth of the federal government, at first resisted by the Supreme Court, and then permitted in the series of cases, the Commerce Clause cases, that every first-year law student studies. Finally, we have this tremendous expansion of federal power. And then during the Civil Rights era, during the 1960s, Congress started enacting a whole slew of federal civil rights statutes, again, recalibrating the relationship between federal authority and local autonomy. And along with the Congress, the Supreme Court, the Warren Court started nationalizing the Bill of Rights so that state citizens for the first time would look to federal courts to protect them against their own governments. Now, I grew up during that civil rights era, and raised on the Warren Court, raised on these civil rights statutes, and people from anywhere toward the left of the political spectrum believed in federal power as an article of faith. To us, states' rights was a code word, and it was a code word for Governor Ross Barnett and Orval Faubus, and for arch segregationists. Therefore, it was with great amazement that many of us watched only one generation later, in the 1990s, the current Supreme Court, a slim but very fast 5-justice majority, reinstitute many of the structures of federalism, the judicial enforcement of structures of federalism. Now, how much of a revolution this is, whether it's been a velvet revolution or a true revolution or reactionary, or whether it's motivated by politics, has of course been a source of great debate. What is beyond debate is that, in fact, the current Supreme Court, since the 1990s, has been interpreting the Constitution in any number of ways that do return power to the state and local governments. Some of the fronts of this revolution, if it is one, are, of course, the limitations on Congress's power under the Commerce Clause, the limitations the court has found on Congress's power to enforce the 14th Amendment, the Supreme Court's newly enlarged idea, someone would say reverting to an original idea, about state sovereignty that prohibits Congress from allowing the employees of a state to sue the state for violations of federal civil rights statutes. And then the two doctrines that will be the center of our conversation today, Prince and preemption. First, the Prince case. The chief case about the 10th Amendment. The 10th Amendment tells us that the powers the Constitution does not confer on the federal government are reserved to the states, respectively, or to the people. After a whole lot of false starts, the Supreme Court has settled on an anti-commandeering interpretation of the 10th Amendment. What the Supreme Court says the 10th Amendment means is that the federal government cannot commandeer either state legislatures or state or local executive officials to do federal work. The Prince case itself, which I think Ann Althouse will tell you a lot more about, involved a federal gun control law, the Brady Act, and it required local enforcement officials to do background checks before people could buy guns. Well, the Supreme Court said you can't do that. If you have a federal mission, you have to hire federal employees, and you have to do the work yourself. You cannot require local officials to do that work for you, unless, of course, they want to. If they volunteer, that's a different story. Well, so there's this anti-commandeering principle. The other, which clearly imposes one kind of limit on another kind of limit on what the federal government can do in enforcing its laws. There's also a limit on the other side in terms of preemption, because there's a limit on what state and local governments can do in promoting their own agendas. The federal government has power under the Supremacy Clause to preempt state and local laws that interfere with the federal mission. So going way back to another great Justice Marshall opinion, McCulloch versus Maryland, the state of Maryland could be prohibited from imposing a state tax, as they've imposed on all businesses, on the Bank of the United States, because Justice Marshall says the power to tax is the power to destroy. If there's a federal mission, the states can't interfere with it. In the 20th century, one of my favorite examples of preemption is Olmstead versus United States, where federal agents who were enforcing prohibition laws went into the state of Washington and placed some wiretaps on Mr. Olmstead, got a lot of good evidence, and Olmstead argued that the federal agents should not be permitted to use those wiretaps against him as evidence in a federal case because they had violated a Washington state law that prohibited wiretapping. The Supreme Court said quite clearly, Washington state can't do that. They can't interfere with the federal agent's mission. So there's this principle of preemption, in addition to this principle which imposes a limit on what the localities can do to resist enforcement of federal government goals. Between those two poles, there's obviously a lot of space. There's a lot of questions about how those principles apply and what the states can do, state and local governments can do, if they disagree with or wish to resist a federal government program in any way. Now, Joan was saying I thought of the idea for this conference over a year ago, and I can actually tell you the exact moment when I thought of the idea, which was in the first week in October 2001, where I had occasion to interview Justice O'Connor in New York City. And I was asking her questions about all sorts of things, and I was thinking at the time, reading Linda Greenhouse's articles about, what do we think about the federal government now? I was thinking the question I would most like to have asked her is, all right, the Supreme Court has just established these rules about federalism. Are they going to hold, now that we have a different concept of our need for the federal government? Are they going to hold in this time of terror? Or may there be room for the boundaries to shift, depending on the nature of the federal interest involved? Now, of course, I didn't ask her that question because I knew she wouldn't answer it. So instead, I'm asking all of you. And this is like an academic fantasy. I started calling people, and here I have before you not only a star-studded cast of brilliant thinkers, but people who are my friends, my colleagues, my mentors, and some people I've never even met, to have discussion about this question I would have liked to ask Justice O'Connor. So this afternoon at the round table, we will all be talking together about a number of different examples where there have been clashes between national authority and local autonomy in the context of the war on terror. We'll be talking about the Detroit chief of police refusing to comply with the FBI's request that he help interrogate local Arab and Muslim men. We'll be talking about the local enforcement of immigration laws, which poses all sorts of interesting issues. We'll be talking about the Bill of Rights Defense Committee resolutions, where over 200 cities and villages at this point, as well as 3 states, have enacted local resolutions in various degree opposing local enforcement of the Patriot Act, and a number of other issues that you'll hear about this afternoon. But to start us out, this morning we have 4 people presenting papers that they've written for the Brooklyn Law Review Symposium issue, talking about background concepts about Prince, about preemption, about history, and about the values of federalism. So instead of doing long introductions, you have biographies of the speakers, so you know that if I tried to tell you a quarter of their awards and credentials and honors, we'd be here all day just doing that. So instead of a lengthy introduction, I would just like to introduce to you Ann Althouse, who will be our first speaker on the vigor of anti-commandeering doctrine in time of terror.
Thank you for that introduction and for covering a lot of the things I thought I'd have to. No, I'm glad to have that introduction because there's a lot to cover, and I'm told 25 minutes, right? Okay, I'll try to do it. Well, as Susan told you, in Prince versus United States, and this was in 1997, the court held that it is fundamentally incompatible with our constitutional system of dual sovereignty, not entirely the 10th Amendment, but the entire structure of the Constitution, for the federal government to commandeer state or local government officials to administer or enforce a federal regulatory program. And this was in the context of the Brady Handgun Violence Prevention Act, which required local chief law enforcement officials to receive paperwork from gun sellers and make what were called reasonable efforts within 5 days to determine whether their customers fell into any of the categories forbidden by federal law to own, to purchase guns. Now, Justice Scalia wrote the majority opinion, 5-4 opinion, and there were several dissenting opinions, but and I'm not going to go into detail really about the struggles that the opinions detail over the lack of a specific text for this commandeering doctrine. The 10th Amendment doesn't really work very well as a text. One has to sort of infer it from the whole structure of the Constitution. It was hard to do with the lack of a text. There was a lot of ambiguous original intent material that could have been interpreted one way or the other. The majority chose to interpret it to on every point where there was a question that could be resolved, that consent would be needed. The court, in Scalia's opinion, decided that they were really talking about the requirement that the states would voluntarily enforce federal law, and then on every point the dissenters interpreted the opposite way and said no, the inference here was that they could be compelled, that state and local officials could be compelled to enforce federal law. And I think that probably anyone reading the discussion of text and intent is going to be attracted to one of those arguments or another based on what they think about whether it's a normatively positive thing for the states to be in a position to resist being compelled to enforce federal law, or whether, on the other hand, they don't see that value. So I really think that what's at the heart of the Prince, and that's why I'm going to gloss over the text and intent, because I think the real dispute is over whether there's normative value to this idea that state and local government officials should be able to resist enforcing federal law. And it's federal law, federal regulation, that is otherwise constitutional. We're not challenging that Congress has the power in these cases to pass these laws and enforce them themselves. It's all about whether they can enlist unwilling state and local officials to help them enforce those laws. Now, I think that an important aspect of whether you find it normatively attractive is whether you think that there's something good coming out of the autonomous functioning of state and local government. And if we go back to the original intent materials on that point, we find very strikingly Madison writing in Federalist 51 in a passage that's often cited by the majority and is cited by Scalia in Prince, the notion that federalism is good because it provides security for the rights of the people, so that there's a connection between the people's rights and the role of the states and local government functioning autonomously. Obviously, many people have the sense coming out of the civil, many of us around today have the sense, remembering the civil rights movement, remembering the Warren Court, that the states are not really making a positive contribution and that they're more of a threat to the rights of the people than a security for the rights of the people. So there's a skepticism about this function. It seems to be maybe just not believable or archaic or never true. But obviously, at the time of the original Constitution, the idea was that the structures really would provide some kind of a safeguard for people, to the point where it was thought that we didn't even need textual rights in the Constitution, that the structures really would be doing the work of protecting people. Obviously, there's a lot of skepticism about that today, but I want to take the position that really the structural protection of federalism in the post-9/11 period really is more protective than the rights themselves. That it's more true than at the time of Prince, that there is normative value to this ability to refuse to be commandeered. And I was surprised that I came to that conclusion, I must say, because when I read the Linda Greenhouse article in the New York Times shortly after 9/11, I remember seeing that she took the position that we'd have to be very vigilant about protecting rights, but at the same time, the court's federalism decisions are probably going to wither away, that the interest in being able to deal with international terrorism, something that needs to be done at the federal level, is going to be so strong that the sort of niceties of federalism are going to seem even more obsolete than before, and they're going to die off. And it seemed to me at that point that, in fact, the doctrine most likely to go would be Prince, because there are so many employees of state and local government, especially police employees, but many personnel out there already in place, that the convenience, the efficiency of using those people to do the work of the federal government is going to be so strong that to hold on to Prince in that environment would be too difficult. And in fact, Justice Stevens seemed to me surprisingly prescient in Prince to have even mentioned international terrorism in his dissenting opinion. He said, when we judge what the power of the federal government is, we need to think what it would be in the time of emergency. We shouldn't put a doctrine in place unless we'd be willing to stick to it even in times of emergency. And he specified the idea that perhaps the threat of an international terrorist may require a national response before federal personnel can be made available to respond. So don't put this doctrine in place. And the doctrine that was put in place in Prince was an absolute doctrine. It wasn't any kind of a balancing test or a multi-factored analysis of any sort. It was simply a right to refuse. It was an absolute right. And it would seem, my initial sense of it after 9/11 was that, well, the Stevens position would have to win out, because there would be such a strong interest in being able to use local personnel, there being so many of them, and the need to coordinate efforts at the national level would be so strong that doctrine that was developed when in fact there was skepticism about the need for national regulation. Why do you need national gun control? Couldn't that be done in a decentralized way that was attuned to local preferences and conditions and so on? That idea would really be overshadowed by the need to actually do something that's controlled at the national level, yet takes advantage of the massive numbers of people that are employed at the state and local government level. But as I looked at this in more detail, I actually changed my mind about it and thought, no, the absoluteness of the doctrine is exactly what makes it work well in the condition where we are faced with emergency and a desire to concentrate power in the national government. Now I want to call attention to something that Scalia wrote in Prince, which was in the very end of his opinion, he takes a stand against pragmatic interest balancing and so on. He brushes off what he refers to as a cluster of arguments that can be grouped under the heading, "The Brady Act serves very important purposes, is most efficiently administered by chief law enforcement officials, during the interim period before federal officials could be put in place, and places a minimal and only temporary burden on state officials. In other words, why don't we just look at how important this law is, how useful state officials are, and how minimal the burden is, and then reach a sort of a reasoned balancing and decide on that ground. He rejects all of that and says, we need to resist the temptation to approve of an expedient solution to the crisis of the day. Obviously, after 9/11, that takes on a quite different light. The temptation is getting much greater. The crisis of the day, well, that sounds a little disparaging of what is actually looks very different than the handgun control problem in Prince itself. But I want to highlight that he did say that he said, this might appear formalistic to partisans of the measure at issue, who tend to value the law for whatever is serving the perceived necessity of the time. But formalism is important. You have to have that absolute doctrine in place. Otherwise, we'll always be giving into the temptation of the day. So he rejected that balancing, put an absolute doctrine in place. And yet, my initial rethinking of Prince after 9/11 was that, this is something more than the crisis of the day, where we're just perceiving an expedient solution. Obviously, it's something much more than that, and that disparaging of, more creative, flexible balancing, it's going to look different. And maybe that absolute doctrine is going to have to go. As I said, I changed my mind in thinking about the doctrine, and I'm now going to support sticking with the absolute doctrine for reasons I'm going to try to explain and that I explain in more detail, obviously, in the paper. I want to call attention in particular to what's always been presented as the normative value of federalism, that it is there to protect the rights of the people. The majority says that, the dissenters also say that, but they tend to say it in the context of asserting that the rights of the people aren't involved. Justice Breyer, in particular, calls attention to this idea that federalism doctrine needs to always be justified by its being in service of liberty. So that unless you can show me that liberty is at stake with respect to this doctrine, you shouldn't have that doctrine. So it shouldn't be preserved just as a constitutional relic. The arguments for it aren't strong enough unless you can connect it to liberty. In the past, all of the historical developments of federalism were done in the service of liberty, basically moving power toward the federal government. So I want to focus on this idea that there is a service of liberty involved in preserving the Prince Doctrine, even in this period after 9/11, where the temptation to cast it aside or to at least make it bend is so strong. First, I want to bring out that the motivation behind the Prince lawsuit itself was an idea about constitutional rights. The rights were Second Amendment rights. The sheriffs whose names are on the caption were both people who were interested not just in avoiding burdens on their workload, but also they were interested in gun rights. So they had a strong, more robust version of what Second Amendment rights were than probably the courts would be willing to adopt. And in fact, their lawyer, who was someone who specialized in Second Amendment cases, not federalism cases, basically said, we're relying on federalism because the court understands 10th Amendment issues, doesn't really understand the Second Amendment. Of course, what that meant was they don't have the strong, idealistic, expansive vision of the Second Amendment that I have. So I'm not going to expose that to the courts, though, they're probably rejected. I'm going to rely on federalism, not because I believe in federalism per se, but because it's the way of securing the rights that I believe in, expansive Second Amendment rights. And they did win on that ground. So there was a motivation based on rights that led the sheriffs in Prince to assert the federalism ground, which they then won on. So federalism worked as a way to win and to preserve what was a robust vision of constitutional rights, which the courts probably would not have adopted. Similarly, in the post-9/11 period, we're seeing robust, idealistic, maybe naive, maybe clearly wrong in a lot of cases, ideas about constitutional rights, or ideas that the court itself wouldn't adopt if it were directly asked to enforce constitutional rights. The pressure of the national security emergency, it tends to push the courts toward a more restrained position with respect to rights enforcement. I talk in the paper about the Korematsu case where the court accepted the exclusion of the Japanese from the West Coast during World War II, and bending and minimizing its interpretation of equal protection rights because of the pressure of national security. I think that we might expect that if rights were presented directly, that the court would feel similar pressures about that today. By having this ability to resist commandeering, however, some of the robust, idealistic interpretation of constitutional rights is able to survive, and it survives in a political dialogue, a political give and take between state and local government officials and the federal government. And that's, I think, what we're seeing in the ACLU Bill of Rights Defense Committee resolutions, where you have, in particular localities where people have, and one of the benefits of federalism is that people have different ideas in various locations. I mean, maybe in the western states during the time of Prince, they had robust ideas about Second Amendment rights. In my hometown of Madison, Wisconsin, they have robust ideas about First Amendment rights and Fourth Amendment rights and so on. And they think the Patriot Act, or they think that the surveillance of citizens violates various rights. Now, these are rights which, if presented directly to the court, I would expect the court would feel a lot of pressure to bend to the interest of the federal government. The assertions that the rights aren't really so big, but the local culture, not everywhere, but in some places, the local culture really does maintain this more vibrant, robust, perhaps too idealistic, but idealistic attitude about constitutional rights. And because of the Prince Doctrine being in place, they were able to create this resistance. Now, in the long run, it may not survive. It may be that a court, if it ever got a case on the subject, would reject the Prince Doctrine, but maybe it will never even get into court. I think that what we're seeing and what we've already seen is really a period in which the belief that there is an ability to resist commandeering has emboldened various local officials to refuse to participate in things that particularly appear to them to be violative of constitutional rights. That has created a kind of a give and take between the federal government and state and local officials, where state and local officials have some ability to push back against assertions of federal power precisely because it is an absolute doctrine. Notice that if they're going to refuse, if state and local government officials are going to refuse to contribute to the anti-terrorism efforts of the federal government, they are really exposed and need to give a good reason, a compelling reason for why they're doing what they're doing. That pushes them to be able to be, it pushes them to articulate their reasons in terms of constitutional rights, to specifically speak in that idealistic voice, not just to say we won't do it, as we remember happening in the civil rights era, but to explain why they're not doing, why aren't they helping with the fight against terrorism. You need to come forward with a very good reason to be able to justify that in the political discourse as you stand on this Prince right. But I think that the existence of the Prince Doctrine as a basic place where they can stand and say we don't need to participate allows them to then move on to make the argument that the reason we're not participating is because we do maintain this strong version of rights. And the way to try to get legitimacy for this refusal, as opposed to reminding us of the civil rights era resistance to desegregation, is by particularly presenting your resistance in terms of a robust vision of constitutional rights. And being able to do that then requires a response from the federal government either to modify what they do, to present their efforts in ways that are careful about constitutional rights so that it doesn't provoke this kind of resistance, to do things to inspire cooperation. And that ability to resist, to stand on the Prince Doctrine, is what really forces, I think, the federal government in presenting its various efforts to think about constitutional rights, to frame their efforts in a way that is sensitive to constitutional rights in order to remove this ability that state and local government would otherwise have to justify their refusal by saying that we are the ones who care about rights, who have the proper view of rights. So that I think that there really is a value to preserving the doctrine and preserving it in this absolute form, precisely because it empowers state and local government to take a position which they really are going to take in terms of constitutional rights. It's really only where the federal government appears to be overreaching that state and local government officials are going to be emboldened to resist the anti-terrorism measures of the federal government. To the extent that the efforts of the federal government are not overreaching, they're probably going to cooperate. In fact, they have so much motivation to cooperate. They're public servants too. They would be subject to all kinds of criticism if they didn't cooperate. They need a good reason not to cooperate. So I think that the Prince Doctrine really works as a mechanism to create a beneficial give and take, to create pressure that in the long run really does work to further the respect for rights, and to further it more than would be the case if those rights were presented directly in court. And I think if you went to court and resisted federal anti-terrorism efforts with direct arguments about constitutional rights, that one might encounter courts that would resist expansive interpretations. So by having the ability to use an absolute federalism doctrine, you don't really even need to go into courts. You have a doctrine that's in place to permit people to resist commandeering, to argue for the reason for that resistance and refusal to cooperate as being based on strong constitutional rights. I think that avoids some of the deference that you would see coming from courts, deference to the federal government's efforts. And so I want to recommend keeping the absolute doctrine in place, not doing any kind of balancing because of emergency, because I think once you're in court and you're balancing the doctrine based on emergency, that courts are going to tend to defer to the federal government's vision of what is an emergency. They're going to see themselves as lacking capacity to say what counts as an emergency. I mean, I might call attention to the fact that in Prince, Justice Stevens specifically was willing to defer to Congress's idea that it was an emergency, that we needed gun control, that there was murder, even though that was murder is a decentralized occurrence that could be dealt with at the local level. So the amount of deference that one would see in courts, I think, ought to be a reason to see the ability to resist commandeering as something that serves the interests of liberty. And then to go back to Justice, am I running out of time? Am I over? Oh. To go back to the idea that if we're going to have federalism doctrine, it needs to be justified as serving the interests of liberty, which is what the dissenters required and said was not there in Prince. The argument that I want to make is that it really is there now, and that to the extent that, so that the anti-terrorism situation, even though it justifies a more centralization of power, because we really do need to have anti-terrorism efforts done at the federal level, you really do need national coordination there in a way that you don't with respect to, I would say, some of the gun control and so on, where you could have had local regulation. You really do need a national effort in this area, but it's the fact that in the post 9/11 period, it's more apparent that the anti-commandeering doctrine works in service of rights. The efforts that we've seen at the state and especially the local level are specifically about a robust vision of rights, and I think that it has an effect and creates a beneficial dialogue about what rights are, even if some of the cities, in their idealistic city council meetings, even if those cities are taking maybe an broad interpretation of constitutional rights. I think the fact that that idealistic voice is in the process and is being said by people who are in a position to withhold their cooperation, that creates a beneficial pressure on the federal government to frame its endeavors in a way that is respectful of rights, that inspires cooperation from people who could refuse. And I think all of that is a good thing, and it shows that the federalism doctrine of Prince really does work in the service of liberty, something that the dissenters in Prince weren't willing to see, but that I think the current environment does point out.
Thank you, Anne. Ernie Young is now going to comment on Anne's.
Well, I want to thank Susan Herman and Brooklyn Law School for having us. The big problem I have in commenting on Anne's paper is that I agree with almost every word in it. And that's somewhat surprising, given I think it's fair to say we come from somewhat different political perspectives. My own inclination is to say that whenever the city councils of Berkeley, Cambridge, New Haven, Madison, and Austin agree on a common political stand, they must be dead wrong. And in fact, I do tend to think that a lot of the reaction to the Patriot Act has a certain element of hysteria in it. But as a conservative who believes in federalism, I'm willing to say that the structural principle embodied in these resolutions and other acts of opposition is a lot more important than the possible wrong-headedness of the stance that these governments have taken. And I think it's one compliment that you can give to Anne, that I suspect she would come out the same way in cases that the ideological valences are reversed. Now, I want to talk briefly about two topics. So one is the relationship between the commandeering doctrine and federalism in general, to liberty, and particularly in the context of the war on terror. And then the second point is directed less at Anne's paper than at the phenomenon that I think you see in this symposium as a whole, which is the kind of reconsideration of federalism by political liberals, and the kind of rediscovery of federalism by political liberals. And I want to talk a little bit about that phenomenon as well. So, first, commandeering and the war on terror. The first thing to say is these state and local resolutions and acts of opposition illustrate the basic relationship between federalism and protecting liberty. And it demonstrates the general point that although you can have codifications of individual rights and you can have the enforcement of those rights by courts, those are often what Madison called parchment barriers. Sometimes you need institutional constraints, actions by other institutions constraining the government. Sometimes it takes a government to beat a government. And I think it's worth focusing a little bit on the mechanisms by which these kind of constraints arise. One is that state governments provide a rallying point for political opposition. The classic historical example here is Virginia and Kentucky resolutions. But it's recognized throughout First Amendment law, for instance, that sometimes people, in order to speak effectively on a topic, need an institution. That's why, for instance, the NAACP was protected. That's why we have a First Amendment right of association. Sometimes people, in order to voice their opposition to the government effectively, have to be able to do it together through intermediary institutions. State and local governments function that way. I think Jason will probably talk about that some as well. The second is one that Anne highlights, and that is that states and local governments can articulate an alternative understanding of federal rights or an alternative conception of those rights under their own constitutions. This may be one way of addressing the kind of classic problem of under-enforcement of various federal constitutional rights when courts are called to enforce them at the behest of individuals. A third point is that these situations, these resolutions, illustrate the need for cooperation in the enforcement of federal law. Federalism divides governmental power, divides governmental enforcement assets, so that it's rare for the federal government to go into any area that requires comprehensive enforcement and do that effectively without state and local cooperation. Think of the environmental laws, for instance, which are largely basic policies formulated at the federal level, but there's no way that those laws can get enforced without a lot of state and local implementation. I think that's a good thing, because when you rely on other institutions of government to enforce your law, then you have to persuade them to go along in many instances. You have to make the case that what you're doing is reasonable. The more people you have to persuade in order to enforce the law, the more reasonable you're likely to have to be. And the fourth mechanism is a much more long-term mechanism, and that is the function of the states as seedbeds of political turnover and political diversity. I think one problem you see in a place like Britain right now, for instance, is that the party in opposition doesn't have any opportunity to kind of build momentum by demonstrating its competence to govern, because there's nothing that the party in opposition runs. There's no jurisdiction in which they're in charge, in which they can demonstrate we are capable of governing. We have interesting alternative policy options that we want to see. The states provide that, in our system. The Democrats may be out of power in Washington. They may be out of power for a while, but they run several state governments, and they can demonstrate competence to lead on that level and make the jump to the big leagues. It's no surprise that 4 out of our last 5 presidents were governors of states while their party was in opposition in Washington, and that the leading Democratic presidential contender is the governor and former governor of the state of Vermont. So, the second general point about federalism and liberty is that these resolutions fit into a long history of state opposition to federal initiatives, unpopular federal initiatives, and some other examples in addition to the Alien and Sedition Act. Think about the nullifiers in the context of the War of 1812, the Hartford Convention's opposition to the embargo on Great Britain. Now, some of these acts of opposition are more attractive than others. Some of these historical episodes, the obstruction of the draft in the North during the 1812 war, for instance, illustrate how far these acts of opposition might go and the real wrench that they might throw into federal policy. And that's something we ought to think about. Some of them are more attractive. Professor Finkelman's going to talk about state opposition to the enforcement of the fugitive slave law as an early example of this kind of opposition. The next point I want to raise is just throw something open for the discussion period, and that is to ask that to the extent that the one function of the commandeering doctrine is to protect the ability of the states to articulate alternative views of rights, alternative political positions to what the federal government is doing. Why don't we think of these as First Amendment cases? Why don't we think of these state and local governments as having a right to speak, a constitutional right under the textual First Amendment? Forget about the vague contours of the 10th Amendment. Why isn't any effort to preempt something like a state resolution unconstitutional under the First Amendment? It seems to me that the resolutions are an easy case. They are simply an expression of political view. But we've long since crossed the Rubicon of speech conduct in First Amendment law. And so why isn't a refusal to go along, a refusal to cooperate in enforcement, why isn't that basically like sitting in at your own lunch counter? It's refusing to go to participate and therefore protesting against the policy that the federal government has articulated. That seems like eminently expressive activity. Obviously, we will have to come up with nuances in a doctrine like that, but it's worth thinking about a little bit. And then the last point about federalism and liberty and commandeering in particular is simply to ask, where is the discussion of the political safeguards in these cases? Why does Justice Stevens, who is in the majority in Garcia, talking about how we don't have to worry about protecting the states from the federal government because the states are represented at the federal government politically and they can work all this out, and the federal government's unlikely to oppress them and do anything stupid because there's these political safeguards for federalism? Why does he forget about all that when we come to the context of the commandeering doctrine? Now we're worried about protecting the federal government from the states, right? We're worried that the states will do something to throw a wrench into federal policy. But surely the federal government has political resources to assert against the state. Surely there is strong political pressure to keep the states from throwing too great a wrench into federal policy. And it seems to me that to the extent that nationalists forget about the political safeguards arguments in these contexts, it suggests that maybe they were never really serious about them in the first place. But I think these political safeguards arguments are strong. I think it's unlikely that you will ever see much of a wrench thrown into federal policy, particularly on the war on terror, just simply because the political pressure is likely to be so great. Now, this is something of a double-edged sword, because it suggests that states are unlikely to be that much of a protection for liberty in this context as well. All right, well, I want to switch gears and talk about the liberal embrace of federalism. And really, the first thing I want to say is welcome to the dark side. Right? I'm glad to have you. But the second thing I want to say is, where have you been all this time? Right? It seems to me, having been born in 1968, that opposition to states' rights on liberty grounds is so 60s. It is a creature of our, and we are imprisoned in the history of race in this country. But I think it's time to realize that race is something we have made a very sensible choice to nationalize. We have chosen to nationalize the idea of basic human rights in the issue of race and a number of other issues. And those issues are largely off the table for federalism purposes, it seems to me, in my view. It seems that the contemporary rights issues that we ought to be worrying about are things like gay marriage or physician-assisted suicide or medical marijuana. And in all those areas, it seems to me one characteristic of all those rights issues is that they are the sort of thing that if those rights are going to be recognized on a wide scale, it will be because they were tried out in certain jurisdictions and people saw that they weren't nearly as threatening as people thought, right? People in Texas will know married gay couples from Massachusetts. And once you know someone like that, you're much less likely to be opposed to extending that right across the board. And so it seems to me that federalism can play an essential role in the promotion of these rights. On the other hand, if you nationalize them, you're likely to nationalize them in directions that liberals are going to find unappealing. You think about the darker aspects of the Defense of Marriage Act, for instance, or the proposed constitutional amendments on gay marriage. The other question that I want to ask, though, is that the problem with the liberal embrace of federalism in contexts like the war on terror is it may seem opportunistic, right? And I want to ask you, is there anything wrong with opportunism? And on one level, I think the answer is no. I think Madison and the other Federalists counted on opportunism to keep the system in place. Federalist 51 is not sanguine about human nature. Federalist 51 assumes people are selfish, opportunistic, and it counts on that, right? I think they count on people always having an interest to support structural notions like federalism because they support or oppose policies that would be adopted at one or the other level of government. And so much of the motivation for debates about federalism comes from the underlying policy issues. I think that's probably fine. I think on another level, though, there is a problem with opportunism, and it's really twofold. One is simply the credibility gap. I mean, I think it's very difficult for Justice Stevens in the preemption cases that Irwin is going to talk about. Justice Stevens has written some great opinions about how great federalism is in preemption cases. And I think the majority, the Federalist Five, just read that and they roll their eyes because Justice Stevens has no regard for federalism in a case like Lopez, for instance. And I think in order to be taken seriously, liberals are going to have to be willing to think about whether they should be a little more consistent in their support for federalism, even in cases where they may not like the results. The second point is more long-term effects. Commandeering shows that some of the doctrines that liberals may have opposed on political grounds, in a case like Prince, it's about guns, for gosh sakes. Guns are things that people want to have done in Texas and bad places like that. Later on, the same doctrine becomes very useful for protecting liberal causes, liberal rights. And it's going to be difficult for people like Justice Stevens to come about face. And if he had prevailed in those cases, we would not have this instrument for opposing potentially illiberal policies at the federal level. So, in conclusion, I'm reminded of the country singer Barbara Mandrell, who made a career out of being country when country wasn't cool. Right? You might think of Ann Althoff as the Barbara Mandrell of federalism. But the great thing about Ann is that she was taking states seriously when state governments, local governments weren't cool. Right? I think there's something to be said for that, but it's nice to have new allies as well.
Since we're going to have a full opportunity this afternoon to discuss not only the ideas presented but their application, I'm going to ask you to save your questions and comments. Ernie was your representative commentator on Ann's presentation. So what we're going to do now is to move to our next presenter, Victor Marr, who will be speaking about state and local power to prevent and redress federal constitutional violations in times of war.
Thank you very much, Susan, and thank you for inviting me. It's an honor to be included among such a talented group of scholars and thinkers. Although I have to say it's sometimes disconcerting to be at these things. Every time I do one of these things with Irwin, for example, and as you'll see when he gets up here, Irwin is one of the best public speakers I've ever seen. I notice he always starts writing handwritten notes just moments before he gets up, as if he's, what should I talk about today? And it's a little, as I say, disconcerting. It reminds me of when I was in law school in the late 80s, I had a friend who used to show up to some of the Yale open book law school exams with his casebook still in cellophane at the final exam. And granted, this was Yale, but that still was a little arresting. What I want to talk about actually goes back to the time I was in law school in the late 80s, and it goes back to an idea that my older brother, who was on the Yale faculty then and is today, floated. And he talked about it a little bit in the late 80s and early 90s, but he hasn't really talked about it in a decade or so, and a lot of people think that's because he's given up on it. But I think it's a ripe idea today, and indeed I think it's a more powerful idea today than it even was then. And it builds on some of the things that Ann and Ernie said. It has to do with Federalist 51 and the ability of states to act as a counterbalance or a check against federal power, but it goes beyond state and local decisions not to implement federal policy. If you look, for example, at the text of Federalist 51 that talks about this division of power, the passage that Ann quotes in her paper closes with the sentence, federalism thus creates a double security because, quote, the different governments will control each other and at the same time will be controlled. And so what I want to talk about is whether states and local governments can go beyond speaking out against federal policies, which I think, whether we style it as a First Amendment or 10th Amendment value is clear. I think states should be able to regulate private entities in ways that are different than the federal government, provided there's no preemption. And I think, as Irwin will point out later, we perhaps ought to read preemption a little narrowly than we have in cases like Crosby and Garamendi involving international affairs and the like. But, and I think states, as Ann points out, can refuse to implement federal programs that they have problems with. But notice that a lot of this local opposition to federal policies today presupposes that the feds themselves, when they implement their policies, may be trampling on the rights of individuals. And so I want to ask, is there any way that states can kind of deter and or remedy those violations? And the idea my brother floated in the late 80s that I want to pick up on now is an idea known as a converse Section 1983 cause of action. The idea would be that state government, be it state legislatures, state courts through their common law generative power, or state peoples through their initiative power, could craft a formal cause of action that would be the mirror of 1983, that would in effect say that there is a state remedy for damages and or appropriate injunctive relief against federal officials who, under color of federal law, violate federal constitutional rights. A number of questions about this idea have arisen and are likely to arise, so I want to kind of anticipate and address some of them. First is, what does a Converse 1983 really add when we do have, for example, the federal courts having already recognized a cause of action against federal officials in this so-called Bivens line of cases, the famous case involving the FBI agents? Well, a few things about that. First, Bivens, because it was made up by the Supreme Court, has been limited by the Supreme Court and may be abolished by the Supreme Court. Indeed, the intellectual kind of foundation of the Bivens cause of action, the more general idea that we can tease out of documents private rights, has been under a lot of fire. The Borak case and other of the predecessors to Bivens have had their legs knocked out, and the Supreme Court today is very reluctant to infer causes of action from the mere existence of rights. And so it's not clear how shaky the Bivens doctrine really is. But more importantly, perhaps, the Supreme Court has saddled the Bivens cause of action with a lot of limitations, perhaps most notably the idea that the officials who are subject to the cause of action enjoy qualified immunity. That is to say, they're not liable for all violations of the Constitution, but rather only a subset thereof. What I want to suggest is that if a state were to create a cause of action, it wouldn't necessarily be limited by things like official immunity. It could dispense with that idea and provide full redress, full remedy for constitutional wrongs. Well, that leads to perhaps the biggest question, and that is, would such efforts by states and local governments be constitutionally permissible? Would they be foreclosed by something in the text or structure of the Constitution? And I think the most kind of instinctive response against a Converse 1983 idea would be kind of a McCulloch versus Maryland argument. How can you say that states could attack federal entities, federal officials, federal objectives? Isn't the teaching of McCulloch, after all, that states are subservient to federal policy, and even though they may not have to implement it, certainly they can't try to undo it? Well, I think that the McCulloch argument is really, while intuitively attractive, unavailing. And I think developments over the last 10 years or so have kind of made clear why there ought not to be a constitutional problem with a Converse 1983 idea. First point I guess I'd make is that the intervening decade, with all these federalism cases and the reinvigoration of states' rights, if you will, has, I think, at base, whether the court has been good about it or not, driven by the vision of federalism reflected in Federalist 51, trying to create a healthy competition between the state and federal governments. And after all, it's that vision of competition that underlies the Congress 1983 idea in the first place. Now you can see this a little bit in Lopez and Morrison, the cases which contract Congress's Commerce Clause power. For example, Kennedy, who provides the crucial fifth vote in Lopez, makes explicit reference to this competition idea in his concurrence. But I think it's even more visible in the cases that Ann talked about, the commandeering cases, New York versus United States and Prince. We talked a lot about Prince. Prince is really the follow-on to New York. Scalia, didn't have to talk much about text and history and structure, although we talked some about that because he relied a lot on the precedent of New York. But in New York versus United States, which involved a federal effort to impose liability on state governments who don't clean up radioactive waste that is generated in their state, the Supreme Court was kind of, I think, not very good at explaining why the federal government cannot tell state legislatures or state executive branch officials what to do. The court said the real problem in this area is accountability. That if state legislatures or state executive officials are doing federal bidding and people don't like it, then they might blame the states rather than the federal government, who's really the one responsible. But accountability is a very weak rationale for New York and Prince because the other things that the Supreme Court acknowledged Congress could do, maybe bribe the states through giving them money to do federal bidding, or preempt the states altogether by doing it themselves and cutting them out of the loop. Those alternative routes create just as much, if not more, accountability problems than commandeering. So I think the real question in New York and Prince is why we would allow Congress to preempt states, but not allow Congress to tell them what to do directly. And one answer is, after Lopez, there's a theoretical limit on how far Congress can go in preempting. There's some territory left after Lopez and Morrison for states to operate free from federal control. Some room, to build on something Ernie was saying, for states to kind of carve out their own identity, to kind of carve out their own vision of the good world, to appeal to the hearts and minds of citizens, to compete with the federal government as a political matter. And if there is that running room, if there is that space for states to operate free from preemption, we don't want state resources to be tied up implementing federal policies lest states not have any time or energy to develop their own alternative agenda. So I think that there is this Federalist 51 vision that underlies Prince in New York as well as Lopez that's doing much of the work. Second, and perhaps more important, there's been a recognition by a number of the justices over the past decade that McCulloch versus Maryland and the idea that Maryland couldn't tax the bank, that holding is itself merely a subset of a broader preemption idea, as Susan said in the introductory remarks, that the states cannot interfere with federal objectives, but, and here's the crucial point, that those federal objectives have to be within the Constitution for the preemption reasoning to apply. If you look at the way McCulloch was structured, the first question Marshall asked was, is the bank constitutional? Then he asked, can Maryland tax it? And as Justice Thomas pointed out in the Chairwoman's case, United States Chairwoman Sink versus Thornton, that structure was not coincidental. The implication is that if the bank had not been constitutional, if it had been ultra-virus, if it had been illegal, then Maryland could attack it. So that the preemption idea is not that states cannot interfere with federal policies, it's that states cannot interfere with valid federal policies, valid federal objectives. And by definition, a Congress 1983 attaches liability to federal officials only when they are doing something that is outside the bounds of the Constitution. That's inherent in the cause of action itself. And I think it makes sense to think of McCulloch as just a subset of preemption more generally, because when you think about it, the Bank of the United States is simply one instrumentality that Congress has at its disposal to accomplish its objectives. The Bank of the United States, the employees of the United States, the statutes of the United States, all of those are just means to federal ends. They're not ends in themselves. So if a state could, and I think it could, do the following, then I don't see why it can't attack federal officers when they are violating the Constitution. And here's my example. Let's say before Lopez, Before Lopez is decided, a state says the following. It says, you know what, Congress passed this Gun-Free School Zone Act statute, and we don't like it. So we're going to say everybody who is covered by the Gun-Free School Zone Act, only those persons who are kind of regulated by the Gun-Free School Zone Act, they shall carry guns near schools. If you're covered by the Gun-Free School Zone Act, you have to carry a gun near a school. That would be in direct contravention to what Congress was trying to do. It would be targeting the same people that Congress is trying to regulate. And yet, because the Gun-Free School Zone Act is itself unconstitutional, see Lopez, I don't think there would be a problem with that kind of a state attempt to attack that unconstitutional statute. So if you can do it for statutes, and you can do it in that way, I don't know why you can't do it for officials as well. Now, someone might respond that, a lot of federalism cases in the intervening decade have really reflected a principle of kind of mutual respect, that that the federal government can't kind of make use of the state governments, it can't kind of regulate. It says because that's implementing the Constitution itself. Well, so too, a Congress 1983 would be implementing the Constitution, and therefore wouldn't violate this principle of respect or civility. Take the Section 5 cases. The Supreme Court has said that Congress cannot regulate states whenever it wants, but when states are violating the Constitution, see Hibbs, they're subject to federal regulation, notwithstanding the new federalism, notwithstanding the respect that the new federalism requires Congress to have for state governments. So I think there's really nothing inconsistent with between a Congress 1983 and the principle that each sovereign has to respect the other. That respect principle ends when one government is violating the Constitution. Brings me to a couple final points, then I'll sit down. One is, could Congress tinker with state-created Congress 1983 causes of action? And I think this is an important question. The former Solicitor General Seth Waxman and Trevor Morrison, who just started teaching at Cornell, a friend of mine, they wrote a piece this summer in the Yale Law Journal that talked a little bit about Congress 1983s, and they took the position that even though states have a right to create these things, that Congress could, if it wanted to, and they said Congress effectively has by enacting various statutes, confer good faith, qualified, it's not good faith anymore, qualified immunity on federal officials who might be subject to these causes of action, because Congress can facilitate federal law enforcement more generally. Their idea was, well, if we have qualified immunity as a policy matter, and we could debate whether it's a good thing as a policy matter, if we have it as a policy matter because it frees up federal officials to be more zealous in their enforcement of the valid parts of federal law, then Congress might be able to kind of reinstate that immunity even if a state-created cause of action tries to abrogate it. And I think that analysis is too quick, because I don't think Seth and Trevor really asked where Congress would get the power to pass that kind of law. Why is that a necessary and proper law to the implementation of any congressional objective? Let me give you an example that may help illustrate the point. Let us assume, as we always have, that federal courts can issue injunctions against federal officers, preventing them from violating the Constitution going forward. So let's say a federal court is about to issue an injunction against a federal official saying what you're about to do violates the Fourth Amendment, so we don't want you to do it. And Congress passed a law that says, you know what, if you issue injunctions against federal officers, telling them they can't violate the Fourth Amendment, then that might deter them from even coming close to the Fourth Amendment line. We would like them to be free from injunctions and free from the possibility of contempt to free them up to enforce their permissible charges more zealously. Now, would that be a plausible, rational instinct on the part of Congress? I think it would, and yet I don't think a court would respect that. I think a court would disregard that statute and say, no, we have a right to enjoin what is federal lawlessness. And the only basis on which you could disregard that federal statute is saying that that's not a necessary and proper enactment by Congress. I don't think there's any other basis for a court to ignore Congress's desire to exclude this remedy. Now, that brings me to a final point that I'll close with, and that is where these Congress 1983 cases would be litigated. I think as a practical matter, they would be brought in federal court. I think that the constitutional question that is wrapped in the state cause of action satisfies Article 3 and 1331 requirement of federal question. After all, it's a federal constitutional violation that is the essential ingredient of the state-created cause of action. It's just like, for example, cause of action under the Federal Tort Claims Act, where you're in federal court as exclusively, but your substantive law is state law. It just contains within it a federal ingredient. For federal court scholars, you can think about the Smith and Moore and perhaps Merrill Dow cases where the Supreme Court discusses some of this, although I think Merrill Dow may have gotten it wrong. I think there's an argument to be made that you should be able to litigate these cases in state court as well. Here, there are some cases from the mid-1800s, Abelman versus Booth and Tarbell's case, that may place some limits on state court power over federal officials. In Abelman and Tarbell's case, the Supreme Court effectively said that state habeas corpus relief, a state court issuing habeas relief against federal officials, violates principles of supremacy. Now, a number of points about that. One, Abelman versus Booth and Tarbell's case may not be that well reasoned. They may not be that correct. There's been a lot of criticism of them over the years. They may not reflect kind of the vision of federalism that reigns today. But even if they're correct, they're narrow in a couple of senses. First, they may be limited to habeas cases and not, state judicial power over federal officials more generally. There are lower court cases that allow state courts to issue injunctions against federal officials, notwithstanding Tarbell's case. Even if Tarbell's case stands for the broad proposition that state courts can't issue injunctive relief of any kind against federal officials, the core of the Congress 1983 remedy is damage actions. And both before and after Tarbell's case, state courts entertain damage actions against federal officials. In the United States Supreme Court, for example, in cases like United States versus Lee, involving the property of General Lee, did not blanch at that state court jurisdiction. But more important than any of that, I don't think Tarbell's case really undercuts Congress 1983 action, because Tarbell's case is not about whose law will apply and what the cause of action will be. It's about which courts. Even if you agree with Tarbell's case that state courts ought not to have any role in pushing federal officials around, that's not what 1983 cause of action is about. It's not about which courts. It's about whether there will be a cause of action and a remedy in federal courts should these things be exclusively federal jurisdiction. And as I said, the Federal Tort Claims Act and the Erie line of cases, those all illustrate that federal courts can and should fully respect state law, even when the cause of action is brought in federal court, unless there is some constitutional federal statutory principle that preempts what the state is trying to do. So even if all these things were brought in federal court, and they do all present federal questions, so perhaps they should, maybe that's the right place for them, I don't think that really undermines the virtue or utility of them too much. Finally, one last point, and it kind of builds on something Ann asked in her paper. Should any of this change in a time of war? Even if this is a good idea, even if this is a sound principle generally, do we really want to apply it today? Well, one point to make is the one Ann did, and that is, look, in times of war, where the federal government may be particularly careless when it comes to constitutional rights, maybe devices like this are more important to think about, not less. But I guess the other observation I'd like to make is that, the war setting we have today may alter and affect the contours of the substantive rights at issue. What may have been an unreasonable search and seizure 5 years ago may not look so unreasonable in light of current exigencies. And if a federal court wants to construe the Fourth Amendment differently today in light of those exigencies, that's fine. So too, for example, the doctrine of enumerated powers may play out very differently in the context of international affairs as domestic affairs. So, for example, to go back to one of the cases that none of us is really talking about that much today, that's Lopez versus the United States. The Commerce Clause. Let me throw out an example. What if Congress passed a law today that says it's a federal crime to possess anthrax near a school? Now, possession of anthrax is no more commercial than possession of a gun, and yet I'm not sure that the court would invalidate that law, even though it invalidated the Gun-Free School Zone Act. I don't know. But the contours of Commerce Clause power, the contours of the Fourth Amendment, they may be affected by the current context, but all of that's kind of beside my point. My point is, if there is a violation of the federal Constitution, then ought there not to be a remedy, and can states play a meaningful role in providing not just political checks, but also a formal legal redress? And I don't see why a time of war should alter that power, if in fact it exists.
And now for some commentary, my colleague Jason Mixoni.
Thank you, Vic. So on the front page of the New York Times today, there's a story about the subpoenas the Federal Commission investigating the 9/11 attacks has issued to the city of New York to compel the city to turn over the tapes of phone calls to 911 on that day. The Federal Commission wants the tapes to help it understand what happened on that day. The city, reflecting the wishes of the families of victims, doesn't want to release the tapes of those phone calls. The incident illustrates the point that I want to make today, which is that there's a mismatch between the doctrines of federalism and the federalism issues raised by the War on Terror. The doctrine is all about the relationships between the national government and the states, but the federalism issues in the War on Terror concern the proper relationships between the national government and the cities. Cities, treated as they are, as mere subunits of the states, have never occupied a very serious place in federalism doctrine. So even in print, the one case in which local officials appear because Congress is directing local sheriffs, Justice Scalia's opinion is all about Congress commandeering the resources of the state and the principles of dual sovereignty. Now, Vic argues in his interesting paper that the time has come for state Converse 1983 actions. To respond to Vic's argument, I'd like to suggest first that the time has come for us to think more carefully about how cities as distinct entities fit into the federalism scheme. Now, local government is a key player in the War on Terror because terrorists don't attack states, they attack cities, and because, as we say in these parts, when you dial 911, it doesn't ring in Albany. In the event of a terrorist attack, local officials are the first and most important responders. Local government is also critically involved in prevention, the main goal of the War on Terror. And importantly, much of the prevention effort is necessarily carried out by law enforcement. Yet states themselves do little policing and criminal prosecuting. These functions are largely left to localities and to the federal government. And despite all of our modern complaints about the rise of the federal government, law enforcement remains overwhelmingly local. In fact, in contrast to virtually every other area of government, the share of local law enforcement has in fact been increasing during the past few decades. As I'm sure Arnold Howard is going to tell us in more detail, local law enforcement is necessary for prevention because it has critical information about terrorist threats to local communities. Local government has for a long time played important security roles in protecting airports, harbors, and highways. Local government often owns and operates bridges, tunnels, mass transit, water systems, and other potential targets. And local government oversees health facilities that might be crucial in responding to a biological or chemical attack. Well, why should all of this matter to Vic? Vic says he doesn't buy the accountability justification for the anti-commandeering doctrine. He thinks instead that the anti-commandeering doctrine allows the states to get on with their own business rather than with the business of Congress, and that this promotes the core federalism idea of vertical competition. Well, if we bring cities and local officials into our doctrines of federalism, the question of commandeering might look quite different. It turns out that the Constitution has something to say about the national government commandeering local security personnel to protect the nation. Article 1 authorizes Congress to provide for calling forth the militia to execute the laws of the Union and suppress insurrections and to repel invasions. Calling forth is a fancy way of saying commandeering. Article 2 puts the president in command of those militia units in the service of the United States. These militia clauses, I want to suggest, might properly be understood to allow the national government to commandeer local law enforcement today. Now, city police are obviously not militia. But there are some striking parallels between the militia of the 1780s and local law enforcement in the War on Terror today. I'm going to mention just two. First, militia units in the early republic, while legally, collectively under the control of the states, were in reality locally organized by town, by town, by town. Second, the new national government needed to be able to call on these local militia units because, lacking its own core of domestic security personnel, the national government depended instead on the mobilization of locals. These two things, localism and national dependency for security, are also true of law enforcement in the War on Terror, making local law enforcement more analogous to the old militia than is the National Guard, which is generally thought of as the militia's successor. So there is, I want to suggest, a textual basis in the Constitution for the national government commandeering local law enforcement today. But setting aside the text for a moment, what about Vic's the vertical competition problem that Vic identifies as underlying the anti-commandeering doctrine? Well, when it comes to local law enforcement, there seem to be several safeguards. Safeguards that are not necessarily present with respect to the general problem of commandeering the state, the problem that the doctrine is all about. One safeguard is that if commandeering is limited to the local militia units, or in my analogy to local law enforcement, the rest of the governmental apparatus of the states remains free to pursue its own programs, giving Vic his vertical competition. A second safeguard, and this one's important, is money. Article 2 of the Constitution talks about Congress organizing and arming the militia when they are employed in the service of the United States. This seems to require Congress to pay the costs associated with commandeering local personnel to carry out federal programs. And in a series of early appropriations acts, Congress understood it had to foot the bill for calling forth the militia. Now, third, commandeering that part of the state apparatus made up of local law enforcement units contains, I think, a natural built-in check. Armed locals asked to serve under the command of the national government are likely better organized and better equipped to resist federal overreaching than are, say, state bureaucrats laboring on a federal radioactive waste program from an office in Albany, the issue that was present in New York and the United States. So the War on Terror highlights, I think, both a particular kind of dependence on local government and the possibility local government uniquely represents as a safeguard for the concerns the doctrine of federalism identifies. Now, Vic argues for Congress' 1983 actions under state law. In the War on Terror, however, the mechanisms of local government I have outlined might better protect the Constitution. Local government, as the 200-odd resolutions opposing the Patriot Act demonstrate, might be more responsive to constitutional issues, including constitutional rights, particularly when local law enforcement officers are asked to round up their neighbors, and especially if the choice is between local police and the U.S. military. The federalism cases talk about dividing power between the nation and the states as a mechanism to protect constitutional issues, and Vic and Akil are right that the protection comes not from a mere diffusion of power, but from the checking role of one level of government on the other. But in that respect, it may be that the national government's dependency on local law enforcement is in fact federalism's best safeguard. And significantly, the interests of local law enforcement personnel are not always identical to those of the states, which might be more aligned with the national government. So in Shays' Rebellion, in 1786, 1787, which is the incident that underlies the militia clauses in the Constitution, the government of Massachusetts was rightly concerned about asking local militia units to put down the rebellion of their farmer neighbors. If states lack, as they so far have, sufficient incentives to pass and uphold Vic's Converse 1983 laws, local officials can still refuse to carry out federal programs. In this respect, return to the language of Article 1. Congress has authority to provide for calling forth the militia to execute the laws of the Union, suppress insurrections, and repel invasions. The language itself suggests that if local officials believe that Congress wants them to do something unconstitutional or unlawful, they can refuse on the ground that they would not be executing the laws of the Union. Importantly, though, the text itself suggests that suppressing insurrections and repelling invasions might properly fall outside of the scope of the Union's laws, perhaps outside of the scope of the Constitution's normal constraints, allowing perhaps less constrained commandeering in times of emergencies, the issue Justice Stevens identifies in Prince. So Vic wants the court to protect us under state law against federal constitutional violations, but perhaps federalism, properly understood to include the unique role of cities, imagines and depends instead on local law enforcement on the ground to get the balance right.
Well, you may all have noticed that in addition to being fascinating on the substance, every one of our speakers and commentators has actually also observed the structures of our day here, which is the timetable. Therefore, before our break, we actually have a couple of minutes. If anybody has an immediate question or comment that you'd like to raise in response to what any of the speakers or commentators have said. Paul?
I just want to, is this working?
Is the microphone working?
Good.
Do you have to turn?
Jason, I just want to add one point to Jason's comments, which is...
Did people hear in the back? No. Okay, Paul, Ernie, can you pass Paul your microphone? Let's see if that's working. Oh, here. Great. Thank you.
Is this working?
Yeah. Just keep talking.
Is it on? Okay, good. Okay. In response to Jason's comments, I believe that the 1792 Militia Act is still in force. And under the 1792 Militia Act, all men in the United States between 16 and 60, all white men at least, although I suspect that the race portion would be no longer valid, are members of the unorganized militia. And therefore, if you wanted to carry your argument based on commandeering the militia, in effect, everyone in this, all men in this category could be commandeered on the grounds that they are members of the unorganized militia. I don't know how far you want to take that, though, because I think it probably comes as a big surprise to most of the people in this room that we are all members of the militia and that we could be commandeered.
Not all of us.
Well, again, one wonders, whether I suspect the gender thing would still be upheld by the court, but certainly the race would not. But the act is still sitting there, and as far as I know, has never been repealed.
Vicki, you want to have the comment?
If a comment on a comment is allowed at this point,
Absolutely.
one of Ernie Young's arguments, which I've also heard Ernie and Ann give in an earlier conference, is that we can distinguish between human rights issues like race, which we decided to nationalize, and other issues, including you mentioned gay rights, which are controversial and therefore they argue ought to be decided at a more local level. And I want to suggest a difficulty I had with distinguishing in that way, because I think if we put ourselves back into 1940s, my memory, I grew up in New York State, my memory is New York State had a race discrimination law, maybe not in the 40s, but in the 50s, well before national legislation. And the argument being made in the court, the whole go slow argument in Brown was this is a delicate matter for the states, you've got to understand it's different there. So that what is one decade's controversy is another decade's nationalized human right, and I think we have to be careful about assuming we're a level of comfort about where those categories fall.
I would think that's an example of the argument. There's no national consensus in 1940 and in fact there's no national consensus in 1954, and it's not until you get a national consensus in the 60s with the Civil Rights Act that anything gets done. And as my colleague Scott Poe has argued, the Warren Court was basically about imposing a national consensus, on the states of the South. But I think you have to have some place for these movements to start, and they tend to start in state governments. And if you had a national rule in the 1940s, it would probably be bad, right? Just like you had a national rule on fugitive slaves in the 19th century, and it was bad. right? You know, most of these libertarian movements start in the states, abolition, gender equality, and so that's what we're trying to protect.
It is good that there are states in which these movements can take root, but there's a difference between sustaining the states as a place where these developments can happen on the one hand, and on the other hand, constitutional doctrine that would preclude national power with respect to those areas.
I'm being a little remiss as moderator. You know Ernie Young because you heard him talk. That was Paul Finkelman who commented on Jason Mazzoni's comments, adding the militia clause. And this is Vicki Jackson, who will be commenting later, who is commenting on Ernie's comment. Next we have Judith Resnick. Let me introduce you to Ed. Yeah, you see, do these work? Is that, I think that's how you have a microphone.
They all
I guess they were turned on.
I need to say two things to this exchange right now. First, I don't think there is a national consensus on race. McCleskey versus Kemp and the affirmative action cases. So the idea that race is over, it's true that people no longer say out loud black, white in a certain way. First of all, race is multiplied, but most importantly, we are still deeply in a struggle about what national and subnational and local norms shall be about the category that race entails. So I just don't think we're done. Second, when I said to a colleague I was going to a conference on terrorism and federalism, he said to me, Morrison and Violence Against Women Act again? The notion that it was terrifying that the national power couldn't reach violence against women and create a new civil right. So I'm just really a little, this idea that the sort of national is this and the state is that, and federalism means X. The Supreme Court didn't even start using the word federalism until the late 1930s, early 40s. Of course, the question of the allocation of authority between states and the federal government is forever, but the it of it and is constantly being renegotiated. And I thought when Hibbs is a great example, the idea that we can say, you said federalism meant X, therefore Justice Stevens, Scalia, anybody you want, I don't care who you want, you can't say it. You can't turn around and say something opposite. Under Garrett and Flores, Hibbs is illegal. It's against the Constitution. Why is the Family and Medical Leave Act and Title VII going to be constitutional? Because of a political and social consensus forged out of state, federal, U.S., non-U.S. world views about the worlds of women and men that has so changed. It's not that federalism is X, Y, or Z. So I'm just confused about the terms. The question is, when we say federalism won't let you, are we saying, do you have 5 votes on the Supreme Court? Are we saying you oughtn't to read a part of the Constitution or the social fabric in a particular way because there's a reason, a set of policies, a set of things that we want. But it's not that we can't. I'm just I want to sort of try to clarify the can't, shouldn't, aspirational, constraints on the court, constraints on local officials to rebel or not to rebel against it. So I'm unclear when the word is you're not allowed, the operative actors, where the source of the authoritative no is coming from.
Ernie, I see you reaching for the mic before I call on Bert. You wanted to respond.
Well, I think you can think of consensus, and there's several different kinds of consensus. There's certainly a consensus that race ought to be addressed as a national issue with uniform. You could make a federalism argument in Hopwood, for instance. The Texas ought to be able to try a different rule from other states on affirmative action because there's not a consensus on that issue. And I think there is no consensus on that issue. And yet, that argument was never taken particularly seriously by anyone. I mean, we have chosen by constitutional amendment to nationalize these issues, and they are in the process of being worked out largely at the national level in terms of national law. Now, I think that the decision to do that makes sense when you have enough of a consensus on certain issues that you can make some headway. And I think that the Reconstructionist Amendment embody certainly a consensus that there shall not be slavery. And then by the time of Brown, a consensus that at least certain forms of racial discrimination ought to be held uniformly unconstitutional. It is true that you have other issues that there is no such consensus on, and maybe those are appropriate levels, not to federalize. But that is simply the issue that has to be played out.
It's just unclear because of who is federalizing. There's an interaction between the Congress, the court, popular social movements, some of which reside at municipalities, some of which reside in other collectives, which are actually trans-jurisdictional. I mean, the list of Wisconsin and Santa Monica and whoever, the People's Republic of Berkeley or wherever, these are places that are not out of sync with each other, but are actually in communication with each other. So it's not like it's a sealed indigenous expression, but they're all on the same website. But you say there's a national consensus. Brown doesn't mark that it existed. Brown is a marker that is trying to make it come into being. And whether McCleskey versus Kemp tells us that it still exists or not is another question. And whether, for example, local, municipal, or state level governments could have more affirmative action than the national government is actually kind of an interesting question that the next decade will debate. So there might be a moment of equilibrium where we have this false sense that we're all in the same page until the next question of what does it mean to have no slavery comes on the page. And then we'll see again that we're forging in a dynamic, ideally cooperative fashion, an understanding of what it means. There's no question that equal protection couldn't possibly mean women. Didn't, in the 19th, 17th, 18th, 19th century. It's made up, there's no way a person reading the U.S. Constitution as a written authority could say that's what the 14th Amendment means. It's made to mean that way by social and political movements. So
we have three other people who wanted to comment. You really okay? Ernie needs to say something briefly, and then we're just going to have three more comments before the break.
I'm not sure how much of that I disagree with, but to say that I think it's perfectly possible to say that there's a lot more consensus on race and a lot more consensus on gender than there is on homosexuality. And so it is more appropriate to decide the first set of issues at the national level than the latter, which is the only argument being made.
Okay, we know what they'll talk about during the break. Bert, you're going.
I want to take a slightly different cut than what I think the subject was that was just being discussed back and forth. And that's that you need a theory of federalism. I've heard this morning three different defenses, three traditional defenses of federalism, the notion of setting up competition, the notion of limiting power, and I want to urge that there's a third, and it's a very important one. And that's the theory of federalism that deals with choosing the appropriate majority to decide a particular issue. And that is essentially a question of capture. That's a question of when you allow someone trapped or embedded in a local majority where they will always lose to appeal over the head of that local majority to a larger national majority. That's Brown. That's what happened in Brown. People trapped in a regional majority where they would always lose were permitted to trump that regional majority by appealing to what was, I think, a fairly strong national majority on the issue. The converse is Morrison. When you get a local majority being permitted to trump a national majority on something and say, no, the national majority would like this, but we, the local majority, don't necessarily want it. And I think you can't just discuss that by talking about general terms like consensus or rightness or the passage of time over in social settings. You need to talk about, you need to relate federalism to theories of democracy. And under what circumstances an appropriate theory of democracy identifies an appropriate majority as the final resolution. And that I don't think the Supreme Court has done very well, and I don't think academia has done very well at this point. Now let me just make a second, and this is a structural answer to Anne's point, which I must say, Anne, I thought your paper was wonderful. I've never seen as good a defense of Prince as that, but I reject it. I mean, I reject it because the thought that there is some sheriff somewhere that we are delegating the power to construe the Constitution of the United States, that's the official that we want to vest power in and say, well, courts wouldn't read it that way. Probably nobody else would read it this way. But we're going to empower some local sheriff to read it that way, and that's a good idea because we'll vest that sheriff with a kind of federalism nullification power to take his substantive reading of the Constitution and ram it down everybody else's throat. And I just find that a very unappealing vision of how substantive constitutional law is going to be defended.
Well, I hope we can play that out this afternoon, but two final comments from Paul Finkelman and then Ann.
Okay, my quick comment is to try and find some consensus between Judith and Ernest. And one way of thinking about this is that the state, there's a very long history of a kind of Brandeisian notion of state experimentation with expanding rights. And in fact, the example of New York is a good one in that New York had a Civil Rights Act which it passed shortly after the Supreme Court struck down the 1875 Civil Rights Act and the Civil Rights Act cases. And in fact, all of the Mid-Atlantic states, New York, Pennsylvania, New Jersey, passed their own Civil Rights Acts because the Federal Act had been struck down. And I think what that goes to is the notion that Justice Brennan had that the Supreme Court provides a floor for rights, not a ceiling. And that in that sense, I think Ernie's point is well taken, that the states go beyond that floor where they can. So Massachusetts has clearly gone beyond the floor, at least this week. The Massachusetts courts have gone beyond that floor with regards to the rights of people to marry who they choose to marry. And obviously, I don't think I would want to see that debated in Congress and have to depend on Congress or the Supreme Court to defend that right, because I think that rights would lose in that situation. What the alternative is, of course, is what we don't want is Congress, in fact, to say, well, no, Massachusetts can't go, and that's where I think the federalism steps in, because I think even if Congress were to pass even if the court were to uphold the Defense of Marriage Act as a national act, I still don't think it can prevent Massachusetts from recognizing the right to marriage for purposes of Massachusetts law. Now that is not a big victory, but it may see an instant population shift as people move out of benighted places like Oklahoma, where I live, or Texas, where Ernie lives, to more civilized places where these rights are allowed. And that would be, I think, the virtue of the kind of federalism that we might want to be talking about.
Well, appropriately, since you started us out, Anne, I'm going to, before the break, give you the last comment for this half of the morning, or a country song, as you prefer.
What the really don't hear is me sing, that would be the worst. But I've disagreed with Ernie before about how much we should feel that, oh, well, the important rights have been identified. Don't worry about federalism. The bad federalism is in the past because we've locked in the significant rights, and now federalism is a place where good things can happen. You don't have to worry about the bad side anymore. And I think that, so I agree with Judith about not feeling secure about that, but I disagree with Judith and Bert, I think, in the sense that I hear you asking, you said a final resolution, that you want this assurance. Ernie's offered you that assurance, and you want assurance. Assurance that the bad things won't happen, that federalism can be trusted, and that rights I picked up the final resolution, or that there needs to be a final resolution about federalism, and that we can't trust, wait, I'm trying to agree with you. I know. I'm trying to agree with you that it isn't resolved and that there will be an ongoing debate about what rights are. But I want to say that we don't need to be afraid of that debate, and that state and local government is a valuable voice in that debate in a good way. I mean, it's interesting, years ago, Kavanaugh Lenikoff wrote this article about dialectical federalism, and they saw there as being two voices in the dialogue about what rights are with the state, but specifically the state courts, giving voice to the more practical law enforcement side of things, with maybe not wanting rights to be too broad because, the kinds of things that we now see associated with the federal government with respect to the war on terror. And the federal courts would come in at the habeas corpus phase, and then they, in their more idealized setting where they talked only about rights would be able to give voice to the more idealistic, aspirational vision of rights, and it was a good thing to have that interplay between the two voices. Now I think with respect to some of the things we're seeing now in the ACLU resolutions and so on, the character of the voices has switched so that we have a place from which an idealistic, expansive vision of rights can be presented at the state level. And because we have federalism, because we have those institutions preserved, they're able to contribute that voice. And then we have the more law enforcement voice coming from the other side. And so I think, the debate continues about what rights are, what rights should be, should they be expansive or not. We can't trust that the feds will be the ones with the idealistic voice. Sometimes they will, sometimes they won't. But what's beneficial about having the different institutions that are preserved and that are there is not that we can trust anyone to always be saying one thing or saying the right thing or doing what is good, but that by having different institutions and different people with a political basis from which to speak, either a small majority or a large majority. Sometimes the small majority will be the idealistic one, sometimes it will be the law enforcement one, and sometimes it's the other way around. And there is no final resolution or assurance, but I want to say that I think that having the different institutions who are in that eternal debate, that is a good thing, and that having that public debate about what rights are, giving people a place from which they could speak, like in a Madison City Council meeting or whatever, is something that has a generative value that we should like in itself and see value too, even if it never gives us the final assurance. I don't think the final assurance is there. And it occurs to me that, for example, I'm in a state that played a role in in articulating rights at a very early point in the 19th century. Things that came to fruition as a federal matter during the Warren Court era were in Wisconsin Supreme Court case law in the 19th century. We've never had a death penalty and so on. So I think there are different rights that have different constituencies at different times, and sometimes you need to have the smaller majority to generate the rights. Now they can also generate things that are negative too, and we may not even be able to agree about what's good and what's bad. But I think preserving the debate and having the large majority and the small majority, the different courts and so on, the different voices in the dialogue, I think on the whole is a healthy and good thing. And it doesn't assure us of good, but I think it gives us a chance to find what is good, and that the political culture of doing that is valuable in itself.
Well, thanks. That's certainly not the last word in the debate, but it is for this half of the morning. So I invite you to join us for a coffee break one floor down, exactly 11:15. We're going to start again. Thank you all.